Hello, and welcome to another 4 Minute Lawyer series. Today, I'm going to be talking about living wills during COVID-19. Now, living wills are something that most people should have, but really don't think about it until they are in the hospital or otherwise. And what it does essentially is to establish a clear and convincing evidence of your wishes, and these are wishes not just if you're going to be going to the hospital for a broken leg or a simple procedure, but at the end of your life. This is going to be something that is going to be specifically, usually for conditions that are not going to be a good recovery state for you, let's say. So, under Florida law, there's three primary conditions: terminal condition, end stage condition, and persistent vegetative state. And if you're in one of these conditions, then it's going to be up to two physicians to make a determination whether or not you are able to recover from that or not. And if you are incapacitated, then you're going to want to have a living will that's going to state what's going to happen to you by your own wishes at that time. So it's kind of important for you to have this sort of document, especially these days with the COVID-19 scenario. What's happening to anybody that's going to the hospital and having a ventilator situation is that typically they are going to be sedated, so that way they can have the ventilator in there. Problem with that is that it does generally incapacitate you. So we've come up with a COVID-19 living will supplement, which is not a full-blown living will, but purely a supplement for individuals that may consider needing it. And that's going to state what's going to happen if you are indeed incapacitated and have COVID-19. That can actually be something that's going to be available on our website under the reading room section. You can just simply download that. It's free and available to all. So that would be good for everybody to have there. Now, again, when we talk about the living will, that's going to be available to you usually through the hospital or a more complete one by an attorney. So, some people say, well, why do I need a living will? And it's really not just for older people necessarily. You really never know when a situation is going to come up that's going to require the use of a living will. All the Supreme Court cases that have referred to living wills have been for women under the age of 40. So this is really not something that is necessarily something just for older people. And also, a living will is, in Florida at least, revocable simply by a verbal statement saying that you want something different than what you may have stated. So it's important that you know what's in there and to keep your wishes kind of directly in line with that document, if that's indeed the case there. So again, as a recap, a living will is in place when a person is incapacitated and at the end of their life, last hours or days of life, then the living will can be what you are going to state as your wishes, other than having to rely on family members or doctors to do that. Hopefully this was informative. If it was, add us as a subscriber and talk to you next time.